Hi everyone, it's time for another travel diary, but this time it was not me traveling, it was a group of scholars and students traveling to Vienna that I want to report on. Yesterday and today we had the privilege to host a meeting with people from Masaryk University in Brno, coming from the Law and Technology Institute from that university. Just in case you don't know it, it's the second largest and one of the most prestigious universities in the Czech Republic. And they do have a rather large law school there, and they also have a rather impressive institute on law and technology. And quite some of the people from there were with us, and we had a two-day event mainly dealing with intellectual property issues. And I gave a kind of an opening keynote yesterday, and I think I would like to share with you what I mentioned there because it reflects a little bit of the thinking I'm in the middle of at the moment, and I would share any kind of feedback on that. So it will be a very short summary of an about 20 to 30 minutes presentation that I gave there. What I did at the beginning was that I introduced our department, and actually, of course, the department is a little bit bizarre, although we have been on the market now for more than 5 years, because already of its title, Innovation and Digitalization in Law, which sounds rather different from I don't know, civil law or public law or commercial law or whatsoever. And I then tried to work on the issue that, in my view, this is a rather proper title for a department because it reflects one basic question here, which can't be easily answered by civil law or public law whatsoever, which is who should be in control or who should own data, who should own information. And I then suggested that this is in some way one of the leading questions of the department and also one of the leading questions of my personal research. And I then tried to give an overview on this, on the very simple question about who should own the data that all of us are producing all the time, everywhere, in any given circumstances. So who should own that? I started this by a slide which simply shows the size of the issue. This is an Internet Minute in 2018. There's a very similar picture from 2021. It's only very few companies. None of them is European. More and more of them are Asian. Most of them are US based, and all of them are called somehow platforms. So it's a few of them, and they produce a lot of market power by simply sitting on an unbelievable amount of data that is growing and growing, and also in Austria, growing and growing, in particular when you look into the behavior of young people. This is a survey of what young people in this country did in 2022 on the internet, and one of the largest and the most growing platforms here is TikTok. All of them do have growth. None of them is European. And I then thought and argued that this is probably going to be even more important in Europe. Tendency will go further into this direction by some US data, where you can see that, for example, almost 20% of the US youth answers on a question that they have been using YouTube almost permanently, and a very similar answer already given when it comes to TikTok. So the youth, young people, you who are listening this, if you are one of my students, you produce this constantly everywhere all the time, and there is a few of non-European companies sitting on this at the moment, and this is what I'm asking about, whether this is the best way one can deal with the issue. I then introduced the first and important policy paper of Ursula von der Leyen, who is, as you know, the acting president of the Commission, and who started this service by a declaration or a policy paper about her leadership. And that policy paper also led into one of the priorities of the European Commission. Digitalization and a Europe fit for the digital age has been a top priority for quite some time now, also in the von der Leyen Commission, who, as I mentioned already, started her service in this position by a policy paper called her My Agenda for Europe. This is from a time when she was not even yet in office. And when you read this, there's a lot of interesting stuff in this. So I would very much recommend you to read the whole text. But there's also one chapter on digitalization there. And within this chapter, there is one sentence which is of specific interest if you think about ownership on data, because she and the situation we are in here as Europeans on this, which is that she states then literally that it may be too late to replicate hyperscaler. Guess whom she means here? So it may be too late to replicate hyperscalers, but it is not too late to achieve technological sovereignty in some critical technology areas. And the question then is, what has been done and what can be done in order to achieve this technological sovereignty? And what does that have to do with the control position or the ownership or the property position on all the data all of us have been producing for all the time for so long now? I gave quite intense reference then to a paper that I had the privilege to co-author together with my brilliant colleague Barbara Preinsack from the Department of Political Sciences in Vienna. I had the pleasure and the huge privilege to write with her on this topic, and we published a paper together last year about in how far those concepts of property and ownership should be further developed, and in how far it is not a good idea to think on these issues with traditional civil law property concepts of the law. The key argument of this is that we should think a little bit different on data and information coming with data. We should not treat this with the traditional understanding of property rights. We should instead establish something that Pranzak and myself call ownership here, and we try to draw a distinction between property and ownership. And the key message in my reading, at least, of our article is let's think about ownership in the sense of controllership more than about property and whether or not people should receive a refund. I also made the point that obviously this is just one standpoint and one can be of different opinions here. But what is not a standpoint, but more a fact, is the fact that whenever you are doing something in the area of data and information technology law, you need to have an intrinsic or explicit concept of in how far you follow an idea of ownership or property. And the second part of my presentation, therefore, was about the hidden concept, or not so much hidden, perhaps, concept on property and ownership as we see in the different attempts coming from the Commission to regain this digital sovereignty Ursula von der Leyen has been talking about so intensely. And I had a little bit of a closer look into this using 3 examples, not without indicating at the beginning that it's a real nightmare how much of information and how much of text has been coming from the European Commission here, and the European legislator, and how difficult it is to draw distinctions and find a common understanding between all those different acts. I then, after having given a very broad overview about what is in the making and what is already in force in the field, try to give 3 examples on how this question on property and ownership and sharing is conceptualized and put into the legal text. The first example is one that is already in force. It's the Data Governance Act, which is an attempt to reorganize governance of data, obviously, and also to help the sharing of data within Europe. And the answer given, and one prominent answer given in the Data Governance Act on this issue, that institutions, companies, hospitals, you name it, whatever, are sitting on data and that there is not sufficient exchange happening on data. One answer that is given in this Data Governance Act is that there is a need for data altruism organizations. So the answer I had a closer look into was in how far all those provisions on data altruism, in particular in Article 16, 17, 18, 19 of the Data Governance Act, all of them trying to organize that you or me as subjects come into the position that we share our data for altruistic reasons, in how far this has already a hidden or not so hidden understanding of who should own the data, which is in this case probably the one who is then supposed to share it altruistically, but after individual decisions. And the important part here, obviously, is the individual decision. So you or me, we should be individually able and more easily able to share our data for altruistic reasons. And I made quite some argument out of this because I tried to make it clear that, at least in my reading, most of us do not really primarily have the issue that we are lacking of a data altruism organization where we could put our data in, or two, and that all this about whether or not they should meet general requirements and whether or not they should be registered and whether or not they should be under the control of a public authority will not lead a lot further if it's not completely and properly understood what people like you and me, data subjects as they would be called in the data protection regime, what you and me have as an incentive to participate in such a game. That was the first example. I then used a second example, which is not yet in force. It's about the Data Act, which is a proposal coming from the Commission, coming again with a very similar and very prominent promise and expectation, which is that also this piece of legislation should help and foster and facilitate access to existing data. This is already the very first bullet point by which the Commission explains why this is important. And again, I try to make the point that if you start the debate then by an understanding such as we can see it in Article 3 of the proposal, which is that it should be the user having direct access to the data, you draw a lot of distinctions and you take a lot of decisions already without having them fully reflected. In particular, again, it's a very individualistic concept, and it's a concept deciding conflicts of interest between platforms or producers of data, the society, and the individual user in a manner that can be justified. And there can be people who can be of different opinions. But the first thing you would need to do is to justify this and to discuss the different opinions, and not to use them as a preset, as something which is in the basement of all the developments you build on this. I also then try to make the point that there are plenty of more of such pre-decisions or conceptualizations in this Data Act that need further discussion in academia, but also in civil society and in politics on in how far this asset data is to be seen as an asset and in how far it is to be then distributed and under which conditions it is to be distributed. And there are decisions on this in the proposal, such as that the user should be the one who should be in the position to ask for the other side to make this data available, and not only to make this data available, but in future, then there should also be a market and a compensation available for this data. And this data should be made available for a reasonable price. And if you don't have a proper concept about who should own here what and who should be refunded, for which reason, it will be very, very hard to tell what exactly a reasonable price will be, so that uncertainty will appear here without any doubt. And then the third example, probably the one which is most intensely debated at the moment, which is the AI regulation and all the issues coming with AI and right to and right on data. I used one article which quite easily and prominently explains the issue many of us have been discussing at the moment, which is how could it be that all these AI systems such as ChatGPT or any of the image creating AI solutions out there, how can it be that they make use of already existing and in many cases also copyright protected data or work? And is there any copyright protection issue here? And if so, how should that be solved? There is a lot of debate on this. I'm even giving an interview on this for the Austrian broadcaster tomorrow. So you will hear more from me on this if you're interested in this. And again, there are people who then start to dig very much into exemptions from copyright, and they dig very much into whether or not there is something like a fair use in European copyright and what that would mean. And my argument again was we can't discuss this, and in particular, we can't discuss what a fair use would be here if we don't have a consistent answer on who should control what here. And that's an ethical, and it's a political, and it's a philosophical question first, and then a legal question. And answers such as the one that we find now in the Digital Single Markets Directive on one additional exemption, which is the text and data mining exemption, which might have some rather complex impact on the question in how far ChatGPT may or may not use copyright protected work. So such answers do not work, and they do not give a legal certainty at all, and they don't help to answer the fundamental question, and that's the reason why they don't give legal certainty at all, which is who should be, under which circumstances, in control of this data, and should it really be an individual? Should it be either the machine or the programmer of the machine or the producer of the work? And how do these individuals relate to each other if you don't have an underlying concept of property and ownership and the relation between those two? Then a little bit more on the text and data mining exemption, and again on issues coming with all the terms used in this. I finally ended with a very fundamental remark, which is that also the AI regulation, in my view, misses the point. There is plenty of text here on what AI is, and there's so much text that even the primary explanation of what this should all be about is not clear. All these risk-based approaches there do not give a proper answer on the fundamental question, what should be controlled here when it comes to who should do what with the data, although the risks coming with this regulation are even harder to tackle than in GDPR and other legal texts here, in particular because the control mechanisms are very, very rigid, and not only the control mechanisms are very rigid, but there is no clear concept on property and property rights here. The only article more or less dealing with this is Article 70, which is about in how far authorities need to respect intellectual property, but that's all. So there is no clear concept on this, but at the same time, not only rigid regulation, but also huge fines coming with this. And again, my closing remark then was, if we continue with this, so if we increase the risks on the one hand, and we increase the complexity and the exceptions and the could be solutions on the other hand, The outcome of this will certainly not be that we will achieve digital sovereignty or technological sovereignty in Europe at the very end. This was the rather fundamental criticism that I wanted to share with you. If you're interested in this, kindly let me know. I will be more than happy to hear from you, either in the comments below or on Twitter or wherever you want to reach me. Thank you so much. Have a good day. All the best. Bye-bye.